Good afternoon, all. Myself, Uday Dev. I welcome you all on behalf of PCSIC for this 22nd Startup Funda event. As you know, every month we carry out a couple of Startup Funda events and to have the knowledge enrichment for our startups and as well as other entrepreneurs in the PCNC area. And in the view of same, today we have got a subject which is for the intellectual property, and today's topic for the startup funda is importance of intellectual property IP rights for startups. So before introducing our guest speaker today, Chirag Tanna, for those who are joining this startup funda for the first time, I just introduce you about PCSIC. Pimpri-Chinchwad Startup Incubation Center is a incubation center located at Chinchwad in the same premise of Auto Cluster. This is a joint venture of PCMC Smart City and Auto Cluster supported by MCCI. We offer our startup, which we call incubates, incubation period of 18 months, and we provide them the basic office space, mentor sessions, networking opportunities, as well as the knowledge enrichment through various training programs like the Startup Funda. These all the facilities which we provide to our startups are free of cost because it's a government-funded incubation center. So those who are listening to this Startup Funda online do use these facilities, and for that I have mentioned in the chat box my email address, so you can get in touch with me. So now we'll come to today's guest speaker, Chirag Tanna. He's a founder, patent and trademark agent of Inc. ID, Intellectual Property Right Firm. Mr. Chirag Tanna is a founder of Inc., which is a intellectual property rights firm based out of India and Singapore. He has more than 15 years of experience in intellectual property rights and is licensed to practice intellectual property rights law in India as well as Singapore. He has prepared and filed thousands of new patent applications, prepared and filed responses to office actions, represented clients at hearing at the Indian Patent and Trademark Office, Intellectual Property Office of Singapore, and US Patent and Trademark Office. So he has been involved in patent litigation matters in India, Singapore, as well as USA. So he has a global presence, in short. So he is the right person to guide all of us at this stage in the what are the rights for startups in IP, intellectual property. So before not with this brief introduction, I will hand over to Chirag for his presentation. Chirag, over to you. Thank you.
Thank you, Udayji, and good afternoon, everyone. So I think, Udayji gave the introduction. We will jump right onto it. But before we start, I wanted to say that we have been doing this intellectual property rights. I've been in practice since 16, 17 years now. But over the last 10 years, 11 years, actually, since 2010, we have focused a lot on startups and we have been handholding them to their intellectual property rights journey. So basically, as IP attorneys or IP agents, we get first eyes on various kinds of technologies. Over the last 10, 12 years, we have seen at least 2 life cycles of founders and startups going from 0 to 100 exits. So we know how IP plays an important role, where it plays an important role, how much you should spend. So this entire talk is going to be focused on the what, where, when, and how, and how to do it judiciously as well. Things that you can do on your own, and then when you should come and talk to us. That would be the whole point of this. So I think the first step I'll focus on is okay. Let us start with what are intellectual property rights. So what are intellectual property rights? Intellectual property rights is an overarching umbrella term under which various verticals are there and governed by various acts. So there is no single act called as intellectual property rights, but essentially an output of the intellect that gets converted into rights, and then it becomes your property, which is not tangible. Tangible meaning you cannot touch it, you cannot feel it, but it has tremendous impact over for a startup, for a company, whether it's big, small, individual. It has much more impact than properties that you can actually see, which means that if it has impact, it has value. If it has value, there should be means and mechanisms for you to own it. Anything that comes out of your brain, it can be a technology problem to a technological solution, or it can be a piece of music or a piece of code or a piece of literature or a story that you write, whatever that comes out of your mind. If you want to sell it to the world, the first step is to own it. And how do you own it is under the various verticals of intellectual property rights. Now, so I told you that they have tremendous impact. So what happens in normal property rights? Let's say, tomorrow you want to go and buy a piece of land. You will first find a broker or you will find a builder. You will go and see that piece of land for yourself, whether it physically exists or not. If it exists, the second step is you will probably go and contact a lawyer or tehsildar to see if that property is actually available for purchase or not. That is called title search. If the title search is clear, that means the person who is representing saying ki this is my property, I want to sell it to you, or you want to buy it from them. If that all is clear, then you can go and buy that property. You will measure the land area, you will measure the FSI, what can be done around it, and then value is decided that way. Similarly, in intellectual property rights also, although you cannot see it, you cannot feel it, but it can be measured, it can be valued. So for every form of intellectual property, right, you first need to do a search whether that property is allowable for you to own or not. And then if that is clear, then the government of that country will give you limited rights in terms of owning that intellectual property right. Right. And very similar to property rights, which you can, after buying, you can reside in it. That means use it, then you can sell it, you can assign it, you can license it. Same kinds of laws and notions are applicable to intellectual property rights, even though they are intangible. The moment you get a granted certificate of your intellectual property right, you can sell it, assign it, get royalty out of it, give it to others free of cost for use, or prevent others from entering your premises. That is called infringement. All that is possible. So laws are similar. One can be seen, one cannot be seen, right? So under intellectual property rights, the most commonly practiced IPRs across the world are patents, trademarks, copyrights, and design registrations. Apart from that, then there are some more which talk about geographical indication, plant variety, which are gathering more and more knowledge in a country like India, which has inherent traditional knowledge. And then there is semiconductor acts and semiconductor layouts that can be protected. But the four main verticals are patents, trademarks, copyrights, designs. As startups, as companies, these are the four verticals that you will see day in and day out. So if I have to give you a visual representation, right, the leftmost thing that you see is the name Nespresso and the logo of Nespresso. These are trademarks. So whether you are a technology startup or a non-technology startup or an e-commerce player or non-creative, whatever happens, that is the bare minimum intellectual property right that you can own as a founder, which is the name of your company or brands under your company. And it is like a must have. You should make sure that at least in the areas that you are practicing, in the jurisdictions or countries that you are practicing, the name is something that you own. Like you take my firm's name is Inc. ID. That is a unique name. Now, if somebody else starts Inc. ID Private Limited or Inc. ID Technologies or something like that and starts selling legal services under it, because it is trademark, I can successfully stop that other person. Because it is my goodwill that I have developed over the last 12 years. I don't want other people practicing or using this name in the geographies that I practice. So at least in India and Singapore where I practice, this trademark is protected. So similarly, Nespresso. Logo, names, trademarks can be trademarked. You can own those names. Next is registered design. You move on towards the right. You see a milk frother, right? The shape there is unique. If the shape is unique for anything, it can be a mug, it can be a cellular phone, it can be a laptop, it can be a pencil box, anything where you want to protect the shape or how a product looks, that goes under design registrations. Now, the entire Apple versus Samsung war that started way back, I think it's been 10 years now, was because Apple had a registered design. It had nothing to do with functionality. Functionality are completely different patents. But what Steve Jobs' first thing was, we will remove all the buttons. We will have a rectangular phone with rounded corner and one button. That was the bare essential design application. This is how our phone should look like. And Samsung copied that design. And the entire Samsung versus Apple war started because the Samsung companies copied the design. And Apple said that technology-wise, you could have done whatever you wanted to do. That's a separate story. But your phones and your pads, computing devices should not look like ours. And that went on for 7 years, the fight between that. So that is the importance of design. Although it only protects what you look and if you change certain things, but ergonomics play an important role. A mouse, for example, a mouse is very important in terms of the way it looks. The shape of a mouse can be protected by way of a design. The shape of chairs, tires can be protected by design registrations. Moving on, if in the realm of science and technology, if you have to protect the logic, construction, working, steps, methodology of anything, but it has to have roots in science and technology, which means that you should solve a technical problem with a technical solution. If that is what you have done, and if that was not done by anybody in this entire world, then there is a possibility that you can own a patent application. So in this case, you can see that the machine, what does the machine do? The machine extracts coffee out of a capsule, mixes it with milk and water in various proportions, and gives you a latte or a cappuccino or an espresso or just warm water. Now, how that extraction is done is the internal engineering. It is a problem that it is technical problem and technical solution that it is solving. That can become subject matter of a patent application. If you are now, there can be one or more. The machine is not just doing one thing. It is doing extracting coffee and adding these things, and there can be various components. If you want the temperature to be there for a specific range, that could be another technology aspect there. That could be another patent application. So although the machine is one, it could have 2 or 3 patent applications depending on what is the objective that you're achieving. For example, now you take a cell phone. A cell phone, the design is only one patent around it. But the underlying technology, the internal working of cameras, the placement of cameras, the internal working of how you scroll, the light mechanism inside it, the technology of communication in 2G standard, 3G standard, 4G standard, 5G standard, all those things are covered by patent applications. So software patents, electrical patents, electromechanical patents, wireless technology patents, Bluetooth patents, telecommunication patents, all of them are bundled into one phone. In today's day and age, if you have to manufacture a cell phone in a particular jurisdiction, you will have to take licenses of at least from 1,000 patents to manufacture one cell phone. At least I think 60 to 70% of those patents will be from Broadcom or Qualcomm, who provide the technology for interfacing or allowing communication. So in the telecommunication domain. But that is the amount of IP that is required for making anything today. If you have to make a car, there are, I think, 179 components. We had done an exercise previously that go into making a car, and each of those 179 patents can have their own those parts can have their own patent applications around it. So this is something that is very, very impactful, but this is also something that is argued day in and day out of what is patentable, what is not patentable, whether how to infringe, whether somebody is infringing or not, and how to get money out of that. So it is a very big circus out there when it comes out to patent. But as technology founders, that is something that your investors will ask you day in and day out. How have you protected your IP? Tell us that. You are doing something is cool, but what will make others stop, or what will disallow others from doing the things that you are doing? And the only answer to that is patent applications, right? And we'll talk about patents a lot more in detail over the next half an hour or so. If you are not in the technology realm and you are in the creative realm, let's say you have written a piece of music, or you have written a storybook or a book or a poem, or if you have made a song out of it, or you are an artist, all that goes under Copyright Act. Now, ideas as such are not protectable. Ideas, if they are technical in nature, which means that technology problem and technology solution, the expression of that idea or the solving of that idea, if it in the technical domain, goes under Patent Act, but expression of an idea goes under the Copyright Act, which means that if all of you have read Harry Potter, right? So Harry Potter was an idea where there was one kid who was a wizard. He was the hero of that entire plot. There was another Lord Voldemort who was the villain, and then they had a duel which spanned across 7 books. Now that idea was not owned by anybody, but the moment J.K. Rowling conceived that idea and wrote it into a book format, That became one copyright, which was literary copyright. The moment a movie was made of the same idea, now that is another copyright, which Warner Brothers owned. So Warner Brothers took rights from J.K. Rowling for that book, made it into movie. The movie became another copyright. If somebody else would have made a song out of it, the song would have been another copyright. If somebody would have made, let's say, Hogwarts, that entire school, it is imaginative, right? So you can imagine it in various formats. But the way you imagine it, it becomes a copyright. So 10 people imagining that same Hogwarts school in different formats becomes 10 different copyrights, which means that expression of that same idea in different formats, even though they may look similar. If I and you look at a sunset and we paint that exact same sunset from that exact same spot, and there is not even 1 degree difference of a dot, still, according to law, my painting is my copyright and your painting is your copyright. How we prove that in a court of law, that is a different story. But expression of idea in a creative format, in the creative field, is copyright. Even if you go into your bathroom today and write a song which nobody in the entire world has heard, or if they'll probably not even hear for another 100 years, it is still your copyright. How do you prove that? That is a separate story. That is where the copyright mechanism comes into picture.
So Chirag, you want to say raw idea is there is no copyright for the raw idea, just
No,
idea.
no. Just ideas cannot be owned.
But
You
when
have to write it down. So
when you process on that idea,
if it is technology, then patents. If it is not technology, then copyrights. Something like that. But ideas as such, no, because this is one question that we
because
get
I
answered.
I had the impression the idea is copyrightable, but it's not.
It is. There is, so in patents, I'll show you how ideas can be protected, but they have to be, a lot of degree of detail has to be there.
Okay.
If ideas have to be protected. Right? I'll give you examples of those things that is there in the patent slide.
Sure.
Right? So similarly, if I have to give you the name of Kodak, so Kodak is a unique name. It's a brilliant trademark. It can be owned under Trademark Act. The packaging of Kodak, artistic work of what is the artwork that goes on the Kodak packaging body can go under Copyright Act because it is artistic work. The entire camera, it has to be ergonomic in nature. The left finger should go here, right finger should go here. It cannot be bigger than your face. All those ergonomics designs, how a camera looks, feels, can go under the Design Act. The internal working, how does light reflect onto a film? What happens when you click? How does it get captured onto a frame? How does that convert? All that can be different patents because all that come under science and technology. It is technical solving a technical problem. The frame rate at which it is captured, all that can become various patents. And then there is something called as confidential information. If you don't want to disclose the process of film putting to the general public, then it can go as confidential information. Biggest example of confidential in the world today is, all of you know this, is Coca-Cola recipe. Whatever said and done, the entire world today has not been able to reverse engineer the Coca-Cola taste. Show me one example in the entire world where you have been able to reverse engineer the exact taste of Coca-Cola in the world. We have been able to reverse engineer drugs. We have been able to reverse engineer perfumes. But Coca-Cola is one recipe, the exact same taste. Nobody in the world has been able to reverse engineer. So all that is protected by confidential information. There are ways and mechanisms. How you function as a company can also become confidential information. What is the hierarchy and or a trade secret, for example. Right? So various forms of intellectual property rights. One more example, TVS on the left, trademarks. The logo is a trademark, name is a trademark. Everything to do with working of an engine or shock absorbers, again, deals with science and technology. That goes under Patent Act. The artwork goes under copyright, and the ergonomics of a seat or the entire vehicle, how it looks, can go under Design Act. Right? So statutory definitions, trademarks, basically they protect a name, brand or logo. You can own them for life. Once the trademark office gives it to you, you can own them for life as long as you remember to renew them every 10 years. As long as you pay those renewal fees every 10 years, you can own it for life. Trademarks, patents, designs are per country, which means that if you file in India, your rights are limited only to India, which means that if somebody applies for that same name, let's say Inc. ID are protected in India and Singapore, which means that if somebody starts a law firm in the name of Inc. ID in Europe or in US, they are legitimate to do so. Okay. Same for patents. If you file a patent in India, your rights are only limited to India. The search, if you remember the title search for this is global in nature, because the patent office wants to see that it is an advancement in science. Science does not have geographical barriers, but courts have geographical barriers. So a court in India cannot tell a person infringing in Pakistan you cannot do this subject matter. It has no rights. That is why rights are territorial in nature, right? So patents are a set of exclusive rights which you disclose your invention to the public, which is where that enablement comes in, which is where that expression of idea comes in, that you have to not only tell what your idea is, you have to tell the patent office and to the entire world, how did you do it? Because a patent is given to you because you are the first person in the entire world who has done something that nobody was able to do. So you tell the world how it was done, like in the form of a research paper. And because you have now disclosed, in return, the government gives you 20 years right to protect your invention. Nobody in that country will manufacture this or make this without your permission. If they want to do it, they have to pay you money or get a license for you. Whether you want to make money out of it or not is secondary, but they have to take a right from you, and only then they can practice. Now this stops at 20 years. After 20 years, there is no mechanism in the entire world where you can get protection for the 21st year. Designs similar to trademarks, but they stop at 10 years. You can extend it for another 5 years in India, but it's a hard stop at 10 plus 5 years. You cannot renew it. Copyrights are little unique because I told you, right, other trademarks, patents, designs are not global in nature, but copyrights are global in nature. So if you file for a copyright in India with the Indian Copyright Office, it is applicable across the world. The life is as long as you are alive as the author of that copyright, plus at least two more generations can get benefit, because it is life of author plus 60 years. So all the Bollywood music that you see today, whatever was made in the 60s and 70s, the heirs of the people who made or wrote those lyrics or made those compositions still enjoy royalty when those music is remade or remixed or used in other movies anywhere in the world. Right? This we can skip. So I'll speak a little more. I'm assuming that because you are incubated here, I'm sure, I think all of you or most of your technology companies, because that is the flavor that is there across all incubators in accelerators and startup and incubators. So this is what a patent would look like. On the left are two, and the middle is the US patent certificate and the US patent document. On the right is how the Indian patent document looks like, right? So I'm sure most of you are here because you have made something cool, you have made something new, or you are embarking on the journey of making something unique. So for all practical purposes, let us assume that all of you are inventors. There is some technology problem that you are solving, which nobody in the world has solved. And that is why you have reached this stage where you have been incubated at an incubation center. So you know how to invent, but you should also know then now how to protect. That is where we come into the picture, right? So what all do you protect? I told you that trademarks, patents, copyrights, designs, at least these 4 things you can protect. Under patents, you need to understand what is the difference between an invention versus discovery versus rearrangement, because discovery and rearrangement of known items are not patentable, but an invention is patentable. Now, what is an invention? That is what this entire story and talk is all about. That how do I know whether what I have done is, it looks cool, but whether it's an invention or not. For example, I think the current rage today is last mile delivery. Zepto, for example, it's on the way to become the quickest unicorn in India. But Zepto is not, it's a business method. There is no technology there that was there. So it could be an innovation or whatever, but it is not an invention because it does not have science backing it, or it does not have technology that allowed it to become a unicorn. So another example is that if I told you that, America is a country which was invented, that is not correct, right? America was discovered. It was a piece of land that was existing on this earth since time immemorial. It was just that Columbus was the first person. The entire world was discovered, but Columbus was the first person who discovered that, okay, this is a piece of land at some portion of the earth which nobody had ever ventured on. So it was a discovery. Take the example of radium as an element. It is a discovery. It was existing in nature. Madame Curie took extraordinary pains to discover that element. She could be credited with that discovery, but she could not say that this is my discovery, so anybody who uses radium from now on should give me money. That is not possible. Mathematical principles that exist, those are things that you don't invent. Those are known laws of physics. Tree falling from an apple, the laws governing gravity were existing. You didn't invent those. Those were all come under discoveries. Laws of physics, any type of science are discoveries. If you discover a new organ in your body which was never known to anybody, it is not an invention. It was already there. You took maybe painstaking effort that people over the last 5,000, 10,000 years didn't take, but still it is a discovery. It is not an invention. So what is an invention, right? So three things you need to remember, and this I will keep on repeating time and again throughout my talk, is what is the problem? That problem has to be a technical problem. In last mile deliveries, I gave you that example before, it is not a technical problem that you're solving, right? It is just consolidation of data. So what is the technical problem that you're solving? You need to figure out how others solve that problem and why are you better. So for that, what is your technical solution to that technical problem? And the third thing is, you're doing all this, there is a technical problem, you're doing a technical solution, but is there a technical advantage to it? So all three things must be there in your brain, must be written down on a piece of paper in the form of a patent application. Only then it starts becoming an invention. Because otherwise, the question is, why are you reinventing the wheel? The wheel was already known, so there is no problem. And then if there was no problem, obviously there is no solution and there is no advantage. Even if there is a problem and you have provided a solution, maybe somebody else did it somewhere else. But so which means that the advantage was already done by somebody else, was gathered by somebody else. So why are you reinventing the wheel? This is a question that we will ask you time and again. Your investors will ask you time and again, what are these three things? Technical problem, technical solution, technical advantage. And this is something that the patent office will also want to see in crisp, clear format with examples, simulation data. Okay, tell me what is the problem that you're solving, right? So these three things will come time and again in this talk.
Chirag, why only technical problems?
So business, I gave you that example of Zepto. Zepto is not a technical problem. They said that we will deliver to your house in 10 minutes. There was no technology. They didn't invent vehicles which would deliver in 10 minutes. They just put across, it was the business method. So business methods are not patent protectable because they are not technical problems that are solving. Zomato, for example, Zomato is not a technical problem. Swiggy is not a technical problem. They gathered data, put it on a platform, made sure that everybody in India downloaded that app and started ordering. They solved a business problem. We will allow discovery on a technology platform. There was no new technology that was built for that. So that is why these three things are very, very crucial. I'll give you again examples of what I mean by technical problem, technical solution, and technical advantage. So what are patents? According to the Patent Act, anywhere in the world, two things are patent protectable: a product or a process. Again, that has to be, once you're clear about the technical problem, technical solution, technical advantage, you need to think whether you have made a product or a process. The products basically are in the field of engineering, which is mechanical, electrical, electromechanical, electronics, somewhat in software, all those things. Processes are typically related to pharmaceuticals, biotechnology, and chemistry, where steps of methods or process of making something are protected. The end result of what it looks like becomes product. So any product or process that has an inventive step. Now again, inventive step is highlighted. What do you mean by inventive step? That is another story altogether. I'll explain that in the future slides. But basic definition of inventive step according to the Patent Act defined by the government is that it is a feature of an invention that has technical advancement, which again ties up to the previous slide, right? Key technical solution, technical advantage, technical problem. If you are able to define all of these three, if there is an advantage, how did you get that advantage? What was your contribution to the solution? All that comes under technical advancement. So what should an invention have, right? So there are across the world, this is the third thing. We will go 3, 2, 1. The third thing is tests of patentability. Any invention that or anything that you feel is patent eligible are basically tested on 3 grounds across the world. This is standard across the world. Novelty, whether it is new or not. That is very easy to establish. You can just take a bucket of water and put a clock on it. You can cut a hole in it, put a clock on it, and you have a bucket with a clock now, which probably let us assume that nobody in the world has done it. You are the first person in the world who cut a circle in a bucket and put a clock on it. Now you have a bucket with a clock. So when you are having a bath, you can look at the clock on the bucket and see the time, which is new. It is cool. It has the third step also. It has utility. It has use also. You can replicate it time and again over hundreds of buckets and hundreds of clocks. So novelty is there, utility is there, but anybody in the world could have done it. So that means that it has lack of inventive step. And I'll explain this further again. But that is what it means. So novelty and utility have only, if you have to give marks out of 100, I will give the marks only 5 cumulatively. So 2.5 and 2.5. The entire story of whether a subject matter is patent eligible or not is the story of inventive step, right? So if your invention is A plus B plus C, let's say, you have done something, you have added A plus B plus C together, and nobody in the world did that. But somewhere in some document in the world, in the entire world, okay, even if you have filed in India, the Indian Patent Office is supposed to check the entire world. Patents, non-patents, thesis, research papers, books, everything they are supposed to make. Because by way of patents, you are advancing the known boundaries of science and technology. Science and technology, again, I repeat, does not have any geographical barriers, or political barriers. So they will check whether that concept was known in theory or literature anywhere in the world. If it was not known, then you have novelty. So 1 tick mark you get. If you don't have that to begin with, then the patent application falls there itself and it will not proceed altogether. So novelty is like the bare minimum requirement, and it is easy to achieve also, because if you have A plus B plus C, you can always tell the patent office ki the document that you are citing, usme to A plus B plus C is there only. I am now adding M and N. So I am novel. So I am more than what you found. But inventive step. Now, again, if your invention is A plus B plus C, you have done something cool and you have gone to the patent office and said that my invention is A plus B plus C. The patent office does their own search. They check patent literature, non-patent literature, research papers, thesis, books, everything they search. And then they say ki nahi, was A plus B was known and B plus C was also known. And nobody in the world maybe joined A plus B and B plus C. And you cannot argue that why they didn't join, but nobody joined. That is proven that nobody joined A plus B and B plus C, and the reasons could be anything, that nobody wanted it, nobody was bothered, and you are the first person in the world to join them together. Even if you are the first person in the world to join them together, if the advantages of A plus B and B plus C, or A, B and C is equivalent to what you have done by joining A plus B plus C together, then you will have novelty, but you won't have inventive step. The way you would convert this to an inventive step is by showing the patent office ki nahi boss, I have B dash, and B dash is what came out of my brain. Because remember the first slide, I told you that output of your brain is what is protected by the patent, by any intellectual property right. So what is the output of your brain which no brain in the world thought of? And that output of your brain is what allowed A plus B and B plus C to now talk to each other. Earlier they were independently existing. Nobody thought of joining for whatever reason, because they didn't have B dash. Now you have that B dash, you allowed them to talk to each other to make something that was interrelational in its parts or processes. And now you have advantages which are more than A, which are more than B, which are more than C, which are more than A plus B, which are more than B plus C, which are more than A plus C, which are more than A plus B plus C. On all of these counts, because of your B dash, now you are having a surprising effect that was not possible in literature, in theory, or even if somebody would have joined them together. That is what the patent office wants to see. And that B dash is your inventive step. Now, it is very easy to look behind and say, ki, nahi, but this B dash also could have been known. So that is the entire argument. This existence of B dash in an inventive step is argued day in and day out, every day in the world, even today. So our Patent Act, Indian Patent Act, started in 1970. US has a Patent Act history since 1790, more than 200 years. But existence of B dash, when a person looked at a technical problem, the technical solution, whether it had B dash or not, is something that is argued even today in all courts of law. Like in India, we have district court, high court, and then Supreme Court. In the US also, you have district court, federal court, and Supreme Court. At all three levels, this is something that is argued day in and day out. What is the point of saying this again and again is that the identification of inventive step is what patent attorneys charge you for. When patent attorneys charges are expensive, that's what people feel. But because it is this that they bring to the table, that is what they help you figure out. Even though it is your invention, while penning it down on paper. And then rearrangement is simple. If you just rearrangement things, again, not an invention. Discoveries are not an invention. Rearrangements are not an invention, because you are just playing around with things. It may be novel, it may have industrial applicability, but inventive step is not there. Anybody else could have done it. The fact that they did not do it is not an excuse to get a patent application granted. Okay, so these things have to be very, very clear. One step before that, those were the tests of novelty as defined by the entire world. Now, concept versus enablement. This ties up with that question that we get asked every day: can ideas be patentable? Now, ideas means concepts. So ideas as such cannot be patentable. If you can show, the patent office will never show let's say if you have built a very cool laptop with 10,000 features and it does something very cool, or a chipset that does something very cool, patent office will not ask you, show me what you have built. They will only check what you or your patent attorney or your patent agent has written down on the patent application. That is what they will check. And there the level of degree of detail should be very, very, very high. I'll give you a couple of examples. Like flying as a concept was known. It was known in birds. Flying, even we credit the entire history, geography, everything of science of flying to the Wright brothers in 1902. They invented the concept of flying. But what they actually did was they figured out a way. Flying was possible even before that. You could fly 10 feet maybe in a straight line. But they figured out two things. They figured out how do you do a sustained flight, which means that it now has industrial applicability, that I will actually go from place A to place B rather than just do a gimmick 10 feet joyride. And the second most important thing was they were able to control flight mid-air. You don't want to always fly in a straight line. That would be pointless again. What would you do with just flying in a straight line? So how do you control flight mid-air? How do you change course mid-air? Was their invention. That is what. So the concept of flying cannot be owned by anybody. Similarly, let's talk about data transmission. The concept of transmitting data cannot be owned by anybody. Ford basically invented vehicles. The concept of driving was not owned by anybody. But the mechanism, the product or process behind one version of flying is what they own. So they had a patent of called wing warping technique. Basically, how do you control various degrees of freedom mid-flight is the patent that they applied for. And that's what they got, right? Similarly, you take the example of Amazon today. Amazon was a concept, so as a concept, Amazon could not be owned, because if the concept of Amazon would have been owned, you would not have had Flipkarts and other e-commerce Jabongs and Mintras today, right? Similarly, Uber. What Uber did was basically it took a signal from your phone, GPS signal from your phone, which was a stationary signal. It crossed that with various moving GPS signals that came from cars. And instead of now you going out on the road and shouting rickshaw, rickshaw, taxi, taxi, or something like that, you could now just silently, in a sophisticated manner, just look at your app and your phone and click on it. So it is a ride hailing app. The concept of ride hailing, although there is a lot of technology that goes in making the simplified example that I gave you, the concept as such was not owned by Uber. Because if Uber was the first company to do that, and if they would have owned that concept, you would not have had Ola, you would not have had Lyft, you would not have had Grab, Gojek, anything across the world. One way of doing that is what was could be protected by Uber and Ola. Now, what you see here, so the concept cannot be protected. Enablement of that concept or expressing that idea or expressing that concept in a technical manner can be owned by patent application. Now, I told you it's a very simple thing, right? You're just crossing one stationary signal with one or more moving signals to hail a ride. But look at, so this is actually not Uber's patent. In 2004, there was this individual who is currently suing Uber. Look at the level of degree of detail that he has drafted. This is a figure from his patent application. It's a granted US patent in enabling that concept of hailing a ride. It's a 2004 patent that was granted. So level of degree of detail should be this to this level. Even if you have not built the app in 2004, that guy had not built an app because in 2004 we didn't have smartphones. Apart from the fact that we didn't have smartphones, there was not GPS. There, GPS was so expensive at that time. In time, only those Tom-Toms and those navigation systems had GPS systems inbuilt in them. But phones didn't have GPS systems. So, but he had a vision. So he, to this level of degree of detail, if you can refine a patent application even without building anything, it can become patent eligible. So concepts, no. Enablement to this level of degree of detail, yes, that can be patent protected. And the first thing before that, every patent act in the world basically talks about what can or cannot be protected. Section 3 and Section 4 of the Patent Act talks about what cannot be protected. Section 4 is basically related to atomic energy, because atomic energy ties up to defense of that country and protection of that country. That cannot be protected. And business methods cannot be protected. Mental acts or playing games cannot be protected. If you come out with a cool game like chess tomorrow, cannot be protected. The board can be protected, or the pieces of chess can be protected by way of design applications. But games, if you come out with a new card game tomorrow, cannot be protected under patent law. Maybe under copyright law or design laws to some extent, but definitely not under patent law. Discoveries of known of scientific principles, theories, theory of relativity, let's say. Theory of relativity could not have been patented. If you applied that theory into, let's say, a rocket or something like that, then that rocket can be protected. But theories as such cannot be protected. Just adding things together, just rearranging things together, all those cannot be protected. Right? Product and process, I told you. If I have to drill down this a little further, what you can actually protect is a process, that is a step or a series of steps, again related to chemistry and pharmaceutical. Machine is basically a product, which apparatus, a device, all those can get protected as a product. Manufacture, so method of manufacture, let's say heat treatment of steel to make wind transformers. That is a method. You're transforming one material into another material. So the transformed material as well as the steps involved in transforming that material become subject matter of a product claim under manufacture. Composition of matter, drugs, X percentage of A ingredient, Y percentage of C ingredient, Z percentage of D ingredient, all come together and they have an advantage of, let's say, managing sugar in an individual or managing some blood cells in an individual. All that becomes composition of matter. So pills, formulations, all that can come protected. Right? Why do we do patent applications? One of the most essential things, because investors ask us to do that. That's the very easiest answer. But from a law point, basically, if you have the invention perfectly drafted, then you get something called as claims in return. I'll show you a patent document after this to see what all goes into a patent document. But if you have a proper boundary, this is a physical property, but an intellectual property is also like a virtual manifestation of this physical property. Anybody who trespasses your property is the red line. They can be sued in the court of law. But legitimately, let's say if you have built something, you can go to bigger companies, ask them to license or give you royalties, and they can pay you money and traverse the blue path. Almost always there will be a green path. Wherever, however good you define your patent application, there will always be an alternative path. But a good patent should be such that this green path, this alternative path, performs subpar than what you have invented. That is the scope of a patent application. Right? I'll just show you a couple of patent documents to understand what basically this is. Right? So patent document is somewhat similar to a research paper, right? Where in a research paper you talk about it starts kind of with a title, then an abstract, then literature review, then what you have done, and the inferences and observations. All that goes into a patent application, except that I think a patent application is a little more, a research paper is a little more focused on inferences and observation and what you have done. But the patent application focuses obviously on all those things, but it also focuses on how a lot. So 70% of weightage in the patent application goes on to the fact ki how you have done this. That is what the world wants to do. You cannot just say ki, I have done this, I have done this, I have done this. But where is the proof? The inferences and results are not the proof. How you have done that? Whether a person skilled in the art, when they read your patent application, are they able to replicate it? Is that level of degree of detail? Have you hidden anything? If you have hidden anything, again, it is just a concept. You haven't disclosed the enabled idea or the enabled version. So patent application basically talks about the how a lot. So you will see that, this is a patent application for a spray dispensing kiosk. That's the title. It starts with what is the field of engineering that it comes in. Then it talks about the literature review or background of the invention in this case. What are what are vending machines, what are dispensing kiosks, what are the problems related to those. All of that come here. Then you also tell the patent office, okay, maybe other people tried to solve this, but there were still problems there, because remember, you have to write down what the technical problem is. Then you start talking about what do you want to solve by this. Again, what? Okay, right? Not how. You have still not started talking about your invention. So you start telling the patent office, no, my invention will do this, my invention will do that, my product will do this, it will solve this problem. All of that you tell them. And then you start describing. This is the detailed description, brief description and detailed description of your invention from here on. Right? Detailed description of the accompanying drawings. I will show you drawings first. So these are typically all patent drawings will have black and white line drawings only. Photographs, videos, all those are not allowed, because across the world there is one specific standard of a patent application or a format of a patent application that is to be followed. You will not see labeling anywhere unless until it is flowchart. So everything is reference numerals. It seems confusing, but that is what it is across the entire world. So because it is a flowchart, that is why text is allowed. So these are drawings, and then every drawing is detailed, discussed in detail in the main body of the patent specification. So figure 1 is this, figure 2 is another drawing, figure 3 is the flowchart of how it works. Then every item that was there in figure 12, we write at least one paragraph about it, of what it is, what is that part, how does it talk to other parts, why do all these parts talk to each other, what is the advantage that we are getting, why nobody could have done that. All those things, basically you write the entire science, history, geography, everything, construction, logic, working, everything into the specification. Now this is a 13-page specification. You can go on to hundreds of pages also. The more you write, the better chance you have of convincing a patent office that this is your patent application. Now here we also write, now this is not mandatory, but we write what is the technical advancement, because then the patent office becomes clear, okay, this is the inventive step that you are bringing to the table. And every patent in the world, whether it's a 100-page document or a 10-page document, basically ends with claims. This is the definition of your invention. This is the boundary, the yellow boundary that I showed, the fence of your invention. So in one sentence, claim 1 is one sentence. Although it looks like a big paragraph, but you will see that it starts with one capital letter here, and it ends with only one full stop. Everywhere there's no full stop from year to year. So it is actually one sentence which defines your entire invention. This is what you present to the patent office. This is what claim 1 is, what the patent office will first check. Patent office will check whether it is new or not. If yes, then you move on to the next step, the easier step, whether it's industrially applicable or not. Yes, it can be done by anybody. It is repeatable. And then, okay, whether the dispensing tubes were known, whether the spraying mechanism was known, whether locating, they will check for all of these things. And if they find, okay, dispensing tubes were known, body mapping was known, locating was known, spraying was known, then they will take it, okay, all these things were individually known. So you have novelty and industrial applicability, you don't have inventive step. Which is where then you will now have to tell to the patent office, no, maybe they were known, but they were not known in the configuration. And because I joined them together in this format, because my body mapping mechanisms, internal technology is this, that is why I should get a patent, because I'm getting an advantage of something that was not there before. And then claim 2 onwards are optional embodiments. Okay, my dispensing tubes are flexible in nature, or they are made of plastic and all those things. So you will see take any patent document in the world, you will see numbered claims that define the scope of your invention. This is what the patent office will check. This is what a court will check if you tell the court my patent is being infringed. Take anything. This is a surgical instrument. You'll see these drawings, field, background. Here also you'll see drawings at the end. You talk about the human body, where the instrument is used. We show the internal working parts, and then we describe every part in detail: 1, 2A, 3, 3C, and all of that basically then comes in the form of claims. A surgical instrument with multiple degrees of freedom. That is the advantage that we are getting. And then the construction, that how are you achieving that, right? I will go on to the slide again. Yeah.
Yes.
When, again, very important question is before any other disclosure. You cannot file a research paper first, or you cannot publish it on your website and then come and talk to us. It is not allowed. By your own disclosure, novelty will then be destroyed. If you file a research paper on, let's say tomorrow is 5th April 2022, and your patent application is dated 6th April 2022, it is a no-go. The patent office will at some point of time discover that you disclosed, even if it is your own disclosure, it destroys the novelty of your own patent application. So the first thing that we tell people is tell us where, is the moment you think that you have a plausible technology and a plausible solution and plausible advantage, file a provisional patent application, and then go and disclose and shout from the rooftops. All that is possible, right? I will give you some examples of, every patent office in the world has their own website, which you can use to search what others have filed. This is patentscope.wipo.in. You can play around. So the moment a patent is filed, 12 to 18 months later, it gets published. It is not immediately accessible to anybody, including you. Even if you file a patent application tomorrow, you will not be able to see what you have filed for at least 18 months. Right? So every patent office has their, once it becomes public knowledge, then you can reverse search to see what others have filed. So today you want to see what IIT Bombay has filed or what College of Engineering has filed, you will be able to see what they have filed 18 months ago by just putting in their name. Or if you know that they have filed something in the realm of laparoscopic instruments, you can put in laparoscopic instrument and IIT Bombay and then figure out what they have filed, right? So you can play around with a lot of things. This is a very important resource, eSpaceNet. It is a European patent office's site, but it collates data from 90 plus countries. So as a free resource to check, basic check to see whether what you are doing is patent eligible or not, you can use this website.
Right. Chirag, what happens within 18 months if somebody has similar kind of patent requirement and it's not published for 18 months, you said? So
there is a blind spot. So what you see today, you will not be able to see what somebody has filed in the 18 months. So there is some level of presumption that you always have to bark on. I mean, and across the world, that blind spot is there.
But patent office will know, na? What
patent office will know, because they will check 18 months later. So by that time, it will already be published. So it is up to then. At that point of time, the many routes. It depends on if your invention was really an invention. There will be other subject matter in the specification which you will be able to convince. If it is exactly the same, then bad luck. So the onus is on you to make sure that what you have done is really an invention.
So 18 months they are taking as a cooling off period kind of thing. So nobody is
claiming. I'll show you the timeline. In the timeline, you will get to know why that 18 months is there. So this is basically the timeline. So stage 1 and stage 2 is, let's say you are all at stage 1 and stage 2, where all of you have had ideas. We go and file a provisional patent application, because I told you, right, that's the most important step. Having a provisional patent application means you are telling the entire world and the patent office, on this and this date, my idea was conceived. There is no, even if your idea was conceived 24 months earlier, there is no proof. Only when you file a provisional patent application with all the technical solution, technical advantage, technical problem, then it becomes proof of right. It is called proof of right. This document need not have all the technical details. It need not have experimental data, and it definitely does not have claims. The numbered claims, the definition of invention, a provisional patent does not have. Basically, what this is a system that the entire world has agreed to, that you file a provisional patent application. If you file a provisional patent application just in India, it is valid for 12 months everywhere in the world. You don't need to do repetitive filings. For 12 months, it is valid, because 12 months you have to figure out what your invention is. It has to tie up with the provisional, define claims. Okay, this was the technology that I was thinking of, but now what is the boundary that I want? That is defined in claims in the complete patent application. And test and experimental data to prove that you have a technical advantage. Because it is very easy to write, if you're developing a diabetes drug, you can say, you use my diabetic drug and I will ensure blood glucose level under a certain range in fasting and post fasting and things like that. But how do you prove? How will the patent office is not going to take the device from you, or it's not going to take the thing from you? So you show controlled lab results. Okay, we used this formulation, we got these results, but with this formulation we got the best results. So all that goes in test and experimental data you show to prove that whatever you are doing is cool, it has technical advantage and things like that. So 12 months is the maximum time period. At the end of 12 months, you also have to define where all you want this protection. Is it just in India, or you want to, are you going to enter US market? Then you must file in US. If you're going to enter Chinese market, you must file there. If you're entering Singapore market, you must file there. All that happens in the first 12 months. So out of those 18 months, 12 months have gone by. You can shorten that time period also, but that first 12 months is given for you to complete your patent application, do your research, and file a final application with the patent office. Then there is sort of a cooling off period where they will do internal, they don't do due diligence. Patent office at this point of time has not touched your application. You can write a story or a poetry and file it as a patent application. They will still accept it and give you a patent application number. Only when you complete stage 4, that is file a complete application, pay those fees for search and examination, only then the patent office touches your application. It reads what your complete patent application is. It reads what your provisional application, it checks whether it's the same or not. You cannot have a provisional application for a drug and then have a complete specification for a laparoscopic instrument. Then it becomes two different inventions. So that is when they will do all that check, and then they will issue an examination report at stage 6, stage 7. So you reply to that examination report. In India, there is almost always a hearing that is conducted at between stage 7 and stage 8. And that is where a controller decides, okay, whether you have those novelty, inventive step, industrial applicability. If everything is there, then you get a grant. 20 years from the date of filing, not 20 years from the date of grant. The right starts from the date of filing, right? So it's 20 years from the date of filing. But at stage 4, you also need to define where all you want to file this patent application in. And then there are various routes and mechanisms. It starts getting expensive from stage 4 onwards. These are different things. I can quickly focus on trademarks. Again, as I said, these are some various examples of trademarks. Now, everybody in the world calls this a bubble mark, but bubble mark is not its generic name. Bubble mark is a trademark owned by a company which invented this cushioning film. Jacuzzi, again, is a trademark. Technically, this is the hot tub, but there is one company which makes jacuzzi, or the first company which popularized jacuzzis. So jacuzzi is a trademark, not its generic name is hot tub. Jet ski, again, is a trademark of Kawasaki. Actually, this is a personal hovercraft. The point that I'm trying to make is that, things become so popular that they start becoming recognized by their trade names rather than their generic names. That is the impact of a trademark. And if you see Forbes, this is, I think, 2020 Forbes result, where they show that the brand value of a company far exceeds its physical assets. So brand value of Apple, highest in the world, was 206 billion. The impact of intellectual property right of just trademarks was 206 billion of Apple as compared to its physical assets. Its physical assets are probably just less than 1/4 of this value. But that is what a brand does. Once you start becoming bigger, the brand is what you want to protect. Right. What a trademark does, it distinguishes the goods and services from one of the others. These are just various examples of trademarks across the world: words, letters, symbols. Ideally, as a startup, the first thing that you should own is a word trademark. They have the highest value. And then again, words are defined into, I'll show you, depending on the nature of your business. I'll show you that slide first. Depending on the nature of your business, you apply in a particular class. Across the world, this is called trademark classification. So if I am a law firm, I will apply for a trademark in class 42 because it talks about computer scientific and legal. If you have, let's say, developed a software product, now software products becomes a little tricky because it is not compulsory for you to file in one mark in one class only. You can file in multiple classes, but multiple classes will means multiple fees to be paid to the government and multiple fees to be paid to the patent agent as well. Because every trademark is for one mark in one class. But if you are developing a software product, it becomes little more complicated because for a software product, let's say like Facebook is a software product which is software as a service or platform as a service. You will have to protect it in class 42. If it is also a product, it is a downloadable mobile application, so it also comes under class 9, which currently it shows electrical and scientific apparatus, but this is just, I mean, there are much more details of those classes. So also class 9 for Facebook. Now Facebook also has Facebook Messenger, which allows communication between two nodes, so that is telecommunication. So class 38 will also be applicable. It also does advertising and business, so class 35. So for something like Facebook, you cannot just say ki I will apply in one class. You can, but then it becomes difficult to stop others. So if you're something like Facebook or a platform like that, you will have to spend 4 times the cost as opposed to, let's say, somebody like me who just does class 42 in legal services. If you are making t-shirts, then class 25 is applicable. But if your t-shirt brand is same as your parent company, then class 35 also starts becoming applicable, because class 35 is for e-commerce, the name of the company as well. So these are various classes where you file a trademark application is. The steps are similar. You first search. For every intellectual property right, search is the first step. And search is something that you can do on your own. Even if you have to search for patents, every patent and trademark office in the world has a free database. Depending on where you want to file, you can use those databases and do a search. Then you file an application in that specific class. There is a description of goods or services that you have to write. Then the patent office or trademark office will examine it. If everything is good, it will directly go to step 6, which is grant and certificate. If not, then they will give you an opportunity to write a reply to that examination report. In India, almost always there is a hearing that is conducted. And step 7 is where before the end of every 10 years, you have to remember to renew. If you don't renew, it automatically gets cancelled. Right? So that's the journey from TM to R. The moment you file, you can use the word TM next to it. The moment it's granted, you can use the word R around it. Right? These are some examples, but this is the trademark office of how you can search the name and various classes, and you get to see what others have filed, whether they were objected, refused, rejected, all those details you get to see. Right? Copyrights, I explained you right at the start. Anything to do with creative work can get under Copyright Act. These are again various examples. Designs focuses on shape, configuration, surface pattern. So Pringles chips is a design registration. Ruffles lays is a design registration. Treadings on a tire, surface pattern, design registration. Even basic carpets, rugs are design registrations. Clothes, design registration. Sabyasachi is the largest filer of design registrations in India every year. However, there is one thing that is missing across the world is graphical user interfaces. They are very, very unique in today's day and age, but US is the only country which allows graphical user interfaces under design law. Everywhere else, it goes under copyright law, which may seem okay, but it has very restrictive. You should have graphical user interfaces protected under design law, but we still haven't evolved to that. The act does not permit us to do that yet. So if you have unique graphical user interfaces for a software product, must protect them in the US. Yeah, and these are the final 3 things. You should do your IPR search. That is where it all begins, because the question that we will ask, or your mentors will ask, or your investors will ask, that why are you doing what you are doing? People are always smarter and faster than you across the world. Take any invention in the world, right from aeroplanes to cars to Facebooks to social media, you'll always see 2 people at least at the forefront who are building the same thing. The person who does it first and executes it first, or has the IP file first, is the person who wins. Do not go about discussing your ideas in public. People, there are, again, people are better listeners than what you think. You'll go to a coffee shop today, you will see people talking about their ideas. Make sure that it is protected before you start discussing that in public places, and seek professional help wherever necessary. Right? Yeah, this is the last slide. I can take questions now.
Yeah, is there any central database where we can check the IPR?
Not for anything like for trademarks, it is country wise because the right is country wise. They also check country wise. For patents, eSpaceNet is what I showed as a free resource. The ones that we use, they charge around $10,000 to $15,000 a year. So, but eSpaceNet, if you remember, that is the one site, at least as a preliminary thing that you can use.
That is for the patent use. Yeah?
Patents. Again, copyrights is country wise. Designs also is country wise.
What is that site?
ESPACENET.
ESPACENET.
If you just Google this term, it's the European Patent Office's site, but it collates data from 90 plus countries.
eSpace.net.
eSpaceNet is one word.
Okay,
I think
eSpaceNet is one.
Yeah, I think it's dot something else.
Okay.
But if you just Google eSpaceNet.
Yeah. Great. So that's it. I think, Chirag, you've given a lot of information and a lot of myths in your mind about IPs are, I think, cleared. Because what we thought that idea can be patented, but as you say, it's not. That's the biggest hurdle. And I think our startups has also gained a lot of things. So just to brief what you have discussed, that intellectual properties are divided into 4 categories like patent, trademarks, design registrations, and copyrights, I believe. And basically, if it's a technology kind of thing, it goes under patent. And if it's artistic or something, it goes under copyrights. Yeah, so that kind of, and there are a lot of things.
If it's the logic and working or something, goes under patents. If it's the look and feel of something, goes under designs.
Designs, correct. And what are the things startup should look after while having new idea? They should have pre-file the patent, something you mentioned.
Yeah, the first.
And
names, you should own names by trademarks. That's the bare minimum thing that you should do.
Yes, so that's a useful actually information. So now those startups who are on the Zoom platform at the moment, if they have any questions, you are free to ask to Chirag. We have still around 5 minutes. So anyone have a question? Satish or Pranay?
Yeah. Somebody has asked in the chat, what about mobile application? So in trademarks, it comes under class 9. If it is purely a downloadable mobile application, then class 9. If there's a software as a service around it, then class 42 as well. If it is allowing you to chat with each other, then class 38 as well. But class 9, first will be class 9.
Okay. So now I think Satish, you have some question for Chirag?
Yeah. So I have questions. One is related to patenting a product. So suppose you already have a patent for, say, limited number of countries, not all the countries you have done, but later on you find that as far as its usage or convenience of usage is concerned, you want to make some design changes in that. Okay. And the component you are adding for that, suppose that is not new. Okay. It is not new, but the way you have put it and you have made a new design, suppose that makes the convenience much better. Then can you go for another patent?
There is a slight, I won't say 100%, but then there is a possibility. Like, let's say if it was the other way around, if you are not protected in India or you have one patent in India, even let's forget whether it is protected in India or not, assume that it's protected in India, there is something called as patent of addition in India. So it is very restrictive and very rarely practiced nowadays, but under patent of addition, that additional component which piggybacks to that extent, it can be filed. But anywhere else in the world, those tests of inventive step will have to be proven. Novelty is there because you are adding a new thing. Industrial applicability is there because there is something that it is doing which the world wants. But inventive step will always be there. That question of inventive step. Question was, why did anybody not join these two together? You will have to show that it was not possible for anybody to join these two together. And how did you solve that problem? If that is there, then it becomes a new application altogether. No problem.
Okay.
So the inventive step is a critical thing.
Very, very, very. And the hindsight is 2020. Always remember that patent office will always reject, because for them, once they read it, it will always seem obvious. So that's why the tests are that in the inventor's shoe, when the problem was there and these things were known, why did nobody join them together? That answer in theory should always be answered.
Okay.
So the inventive step, what you're doing is should solve the problem, isn't it?
Right.
Why did anybody not join them together? What was missing? If it was, let's say, two pieces of wood together, why did anybody not join together? Because let's say the concept of glue was not known together and I didn't want to use a screw. So then you can have the patent for the glue itself or the two objects with the glue.
Okay.
Okay.
And another question is, if you come up with a business model that involves manufacturing as a service, and that is solving what you say, the business process challenges.
Cannot. The moment you start saying business, it ends. Cannot.
No, what I'm saying that it involves specific machines to do that.
So then those machines can be protected on their own, not the business method, not the business process. The specific machines are not solving the business problem. They are solving a technical problem.
Right.
Machines and their own.
As they are solving that, you make it available in a under one service facility as a umbrella. Then would that
cannot. The moment business method comes in, outright rejection. Okay. It is not, science and technology is not in how you are attaching those machines together. It is in the machine itself, or it's not.
Okay, so machines can go for those patents.
Yeah. Machines are... It will depend on what other machines were there and what is the advantage that this machine is bringing.
And suppose
you are using it is not patentable.
Okay. And suppose you have patent for a product as an invention. Okay, not an innovation. Okay. And then you build several applications on top of it as a in a different form or different size or different purpose. Then the derivatives of that or those applications, those machines can go as a innovation patent.
There is no such thing as an innovation patent. It is only a utility patent or it's not. So if there is nothing beyond this than what I said. There is no such thing. So if those applications again satisfy those three things, then you can have an add-on patent or a separate patent for it. But if they are just new uses of the same machine, then the Patent Act clearly says that across the world it says that new uses of known items cannot be patented.
I'm saying that the earlier patent is some core product.
Okay.
And you build a machine around it.
Okay.
And that machine gives you some noticeable advantages which existing machines for similar purpose are not doing.
But whether those add-on concepts were known elsewhere or not, did you just join them together? The underlying philosophy in a theoretical conversation that we are having right now remains the same. That why did anybody not join them together? The fact that they did not is okay. You have novelty. But why did nobody join them together? What was missing in technology? If let's say you are an electronics engineer, if some other electronics engineer also comes and looks at it, I just had to put these two screws together and I just had to do the red, yellow, green wires. I just had to join them electrically. And I could have done this. The fact that I did not do it is another question. But I could have done it. There was nothing electronically that I had to join or think about. If that is there, then you have novelty but no inventive step.
I see.
Okay. Hope that answers the question, Satish. Yeah. Okay. I think Pranay is having some question.
So I just had a little question. Like we are filing a provisional patent, and as we move along, after a few months, we come to find that there's a probability of design patent as well, technology patent as well. Means
Hmm.
there are multiple patents
Hmm.
with that same provisional one. So is it possible to file multiple patents?
Yes.
Yeah.
Always. Multiple patents, having a good patent portfolio is always better. Like there was a two-wheeler vehicle that we were working on where the design was unique. So the way it looks, that also is protected, but the logic of the how those two coordinates correlate with each other and correlating that with center of gravity and momentum and how it performs, all that was went under innovation patent. So we have done that. And the classic example, take Fitbit. Fitbit is a simple technology which tracks your has pedometer and does things. It is protected by a portfolio of 300 patents.
Oh my god.
And
Great.
when they were litigated, Jawbone was the first company. When they were litigated, they were actually infringing. They went to court and said, no, we have a portfolio, but this was anyways possible on pen and paper. So, and they convinced the court also.
Okay.
So the point is have a portfolio as soon as possible. But again, it depends on how much money you have.
Yeah.
Right.
So
Theranos, biggest example. Everything fake. Today also their patents get granted. April 2021, I have seen a patent getting granted of Theranos.
Okay,
so that's a different talk altogether.
Yeah.
The point is that as money judiciously for India, the moment you start going west and you have series B, C, then you can go and file as many as you want. You should file as many as you want.
Yeah. But the initial phase, they should focus on these 4 types of patents or IP rights they have: patent, trademark, design restriction, and regulations and copyrights.
Copyrights, yeah.
So they should file whatever as
patents and trademarks, definitely if you are technology.
Yeah.
Designs if you are a physical product where the shape if the shape matters.
Sir, means on a single provision you can file multiple technology patents.
No. That again depends on how many problems. Every patent is for one technical solution to one or more technical problems.
So I have.
If your provisional has 3 solutions, then
Yes.
3 different can be filed.
Yeah, so means means basically the question was, can I file, means there are 3 different solutions which I have. So all
of them can go in one provisional.
I can file one single
Yeah,
provisional.
it's not always a good idea, but it can. I mean,
Means
it becomes
because they have a functional use with one another as well.
Yeah. You can because see at this stage what happens is you may not have even real invention comes out when your product goes to market.
Yes.
Across. Yeah. So in the provisional, it is for all practical purposes, it's a theoretical idea. And theoretical ideas will have theoretical solutions, which will be definitely be more than 3 or 4. So you can put them all in one provisional. But if you want to show to your investors a bigger bouquet of portfolio, file separate provisionals.
Yes.
Okay.
So in short, if there are 3 different problems, then they have to file 3 different.
If there are 3 different solutions, then 3 different. If the 3 problems can have one solution.
Okay.
So one solution means one patent.
Okay. So solutions, one solution, one patent. If there are 3 solutions, 3 patents.
3 patents. Yeah.
Okay.
But provisional can be one. That final patent has to be 3, because there you will have to define in the claim. Now, one claim will have only one inventive step. So automatically your claim 2 will become different. And you cannot, even if you write 3 different claims in the complete, the patent office will force you to divide them. These are called divisional applications, to divide them into 3 separate applications.
So it depends on the number of solutions you are offering.
Solutions, correct.
So number of patents changes.
Yes.
And suppose somebody has filed the patent pre-patent kind of thing, and same idea comes into somebody is trying to solve the problem, then he will not be able to do that.
He won't. Yeah, they will be able to file, but then 2 things will happen. One is either they will get shot down during the discovery examination phase, or sometimes things are so much parallel. Like we are fighting a case right now in the US where the difference in filing is just 19 days, and it was impossible for the patent office to figure out. Both proceeded simultaneously. Then there is, at least in the US, there is something called as interference proceedings, where they figure out who filed first, who invented first, all that and who only one. The thing is, for a particular solution, only one person in that country or in the entire world can have a patent application. The second, even if they have, they will not be able to enforce.
Okay. All right. Hope that answers your question. Or any more?
Just had one experience to share. So I have experience with the investor is when I pitch in front of them, so they ask us for a market barrier. And when we say that, so we have patentable technology. So what they say is no, it can be altered. And means, they don't take it, they take it for granted kind of
Yeah,
thing.
they will ask this also, and then they will, because those are the only two statements or questions that they know. So, so I mean, so there is something called as, I mean, then you have to back it up with actual prior art research and all those things.
Yeah.
But they have to read it. No, a person, if the investor is that savvy, either he will not ask those questions or he will have done his due diligence and come, because you will always lie. Lie is a very another term, but obviously you will be in favor of your technology. So
Yeah,
them
so-
asking this question, that is a stupid investor.
So what is the understanding is ki, this patent can be altered a bit and can be used by different big players. That's what they, something like that.
Theoretically, that is possible. That's what the green line, if you remember that thing I told you, the blue line, there will always be a green line. But
Okay.
then it depends on how the patent was granted.
Okay.
What is the scope of the claim? Now that level of degree of detail, nobody does. Even we have been through multi-million-dollar exits. Nobody does that level of degree of detail. This is just a stupid investor asking stupid questions because it is there in his question. But if he goes on that road, it is very difficult to give those answers. For you, for us, for me, it is easy. If you take me along, I'll be able to tell him. But yeah, I have seen this happening.
Okay.
Yeah,
Fine.
what we have observed many times that nowadays investors are saying that okay, you have patent, but that is not a foolproof thing that your idea cannot be copied.
So
Something
money
like
is
that.
made not of patents in India. It is made from execution. So then you have to show we are executing this at a rapid scale. It is not just IP. That is what ideally I think that is what they want to see. The execution and IP is happening hand in hand.
Okay, Pranay, any more questions? Yes, so that ends this session. So thanks, Chirag, for your
No
time.
problem.
And we'll connect definitely down the line.
Yeah.
Thank you.
Thank you.
Bye. Bye-bye.
Thanks everyone. Bye.
Thank you so much.